Mr. Beeson's request to withdraw his counsel in this matter. That is also supported by a certified or a notarized letter I received from Miss McKaylee requesting new counsel due to a breakdown in the relationship. I would invite counsel. Will you please place your appearances on the record at this time?
Tiffany Burks on behalf of the people.
And Mr. Beeson, you're muted.
Sorry. John Beeson, Your Honor.
Thank you, Mr. Beeson. Anything to add to the motion, Mr. Beeson?
No, Your Honor. Ms. McCauley is present, but she has her audio on.
Yes, no, that's fine. Any position from the people on the motion to withdraw his counsel?
No, Your Honor.
All right. Well, in that case, I will grant the motion to withdraw because Ms. McKaylee has indicated a breakdown in the relationship. And Ms. McKaylee, is it your intention at this point to request appointed counsel, or are you going to hire new counsel on your own?
This is a motion for me to get off probation, right?
I think there also is a motion to terminate probation in here. You know what? Let me handle the counsel one first so we can determine whether you're supposed to speak on your own behalf for probation. I had two motions, Mr. Beeson's motion to withdraw, and then also, yes, you're correct. Your next one up is yours to get from probation. So, what's your intention going forward with regard to an attorney?
I do not wish to have Mr. Beeson represent me, Your Honor. I made it clear to Mr. Beeson that I did not wish to sign a waiver, and he manipulated me into signing the waiver, did not give me a copy, and I had to obtain a copy of that waiver, which is why my case was bonded over. It has also been on my record that I have absconded for 2 years, and I've never ran. This is a major problem. It has stopped me from being able to better myself, Your Honor. I am very frustrated. I don't owe you guys anything. I don't owe you guys any community service, any money, and I am still...
Before we even get into the courtroom, let me set the stage for you, because this is one of those cases where the defendant genuinely believes every bad thing in her life is happening for no reason at all. Today's star is what I like to call a perpetually victimized Karen, someone who's always wronged, always misunderstood, and somehow, even when the paperwork, the probation terms, and the judge all say otherwise, that we're in Michigan, dealing with probation, an OWI, attorney withdrawals, and a defendant who insists she doesn't owe anyone anything, while simultaneously demanding fixes for problems she created herself. You're going to hear accusations of manipulation, claims of being set up, emotional frustration, and repeated attempts to rewrite reality in Becomes Need an Attorney, and how the judge patiently, methodically dismantles every excuse without ever raising their voice.
Whether or not she has a notice on her file about fleeing, that was my concern. Secondly, judge found over Ms. Cawley from the prelim. She signed a circuit court waiver. Her case is already bound over, and I explained to her that by signing the document, she did not have to attend in person for the plea not guilty from the circuit court judge. So I don't know if she understood that or not, but you can clearly see there's a breakdown. So I ask the court to grant my motion.
Yep, no, I can see the breakdown in the relationship. I will grant the motion and allow your withdrawal at this time, Mr. Beeson. And I'll ask you, Ms. McKaylee, is it your intention to hire a new attorney, or would you like me to appoint an attorney or have the defender's office assign an attorney to represent you at this time at no charge?
No, I would like to get this motion going. I don't need an attorney. I'm not.
I'll continue with your motion today. I'm just thinking going forward. And is this the only thing you're in front of me on, or is there, because my review of the case indicates there might be another case coming here.
Driving while intoxicated was bonded over in front of you also.
Okay. Who's representing you on that one, Miss McKaylee?
I am currently looking for someone to represent me. I have a lot of support. I am in the FIT program, and we are looking for an attorney to represent me in this situation, also to take care of that absconding that was on my record. That has really put me in a bad situation.
Okay, all right. Well, what I have here,
When you hear an attorney asking to withdraw, that's not something that happens casually. Judges don't like it, courts don't like it, and defense attorneys definitely don't like it, because it usually means the relationship is completely broken. And right here, you can already tell why. Notice how the attorney keeps it professional, calm, and brief. No emotional language. No finger pointing. Meanwhile, the defendant's frustration is already bubbling just under the surface. This is the early warning sign of what's coming: a client who believes her attorney works for her instead of representing her within the bounds of the law, and when a defendant sends a notarized letter claiming a breakdown in the relationship. That tells the court this isn't a misunderstanding, it's a pattern. Courts don't assign new attorneys just because someone's unhappy. They do it when cooperation becomes impossible. That distinction matters, and you're
here is I extended, let's see, probation here for 90 days because of that OWI that was pending in 61st and has now been bound over and will be in front of me in May. And I amended the discharge date from probation to August 23rd of this year based on that. And, based on the additional charge for OWI, I don't see any alternative here but to keep you on probation for that time. Are you still wearing the scram, Miss McKaylee?
I am, Your Honor, and I have been wearing it since November. I have no problem with wearing the scram. I am in cosmetology school because I tried to take CNA and I was denied because I was listed as absconded too for 2 years, which
Yeah,
makes
no,
my
I
guidelines
yeah.
go up, which is a major problem and it's not being acknowledged. So I need an attorney behind all of this stuff that's going on. The amended sentence was not represented to me. When it was represented to me, it was represented to me first without a signature by you. It's just been, I haven't got anything in the mail. Um, it's
Do
been a
we do
lot.
we have
I
a
have,
good mailing address for you, Miss McKaylee?
yes, you guys have a good mailing address for me.
Could what is your current address that we should send stuff to? Okay, yep, that is what we show in the court record here. So that is good. We're at least sending stuff to the right location. What I will do, well, in the meantime, prior to that co conference, and Mr. Beeson has represented you on that case up until this point. Now you don't have an attorney. What I will do is direct you to obtain an attorney within the next 2 weeks. Yeah, so that's gosh, 2 weeks is just going to put you a week before that. If you don't have an attorney prior to that date, what I will do is I will appoint, a court-appointed attorney to represent you, so you have representation at that hearing. So today's order, though I'm going to keep you on probation, it will direct you to obtain counsel on the new case of your choice, or I'll appoint counsel.
peering into what she wants it to be. This is a classic tactic: redirect the conversation away from uncomfortable questions and toward the desired outcome, in this case, getting off probation, but courts don't work that way. Judges handle issues in a specific order, for a reason. And when the judge calmly pulls it back to attorney representation, it's not nitpicking, it's ensuring due process. Because whether or not she has an attorney affects everything that follows. His moment also foreshadows the central problem of the case: she doesn't understand that probation, attorneys, waivers, and hearings all have consequences, and none of them bend just because she's frustrated.
6 months.
Yep, well,
Um,
and given the circumstances, when I have because I do have you on probation for OWI, and if that ever happens and I get someone else that picks up another OWI charge, I keep them. I'm not treating you differently than I treat anyone else. I do keep folks on probation, and it's mainly because I want to be able to monitor whether you're drinking and driving during the probationary period. If you were, then I would take the additional step of holding you in jail. You're not indicating any of those problems, and the scram, as far as I know, has been good for you. So, I mean that you've been compliant with the scram conditions, which is a good thing. That gives me the assurance that the public's safe while you're out there while we get the new case worked out. So, that's all information I can give you.
Judge Rossi, you also told me that you were going to release me from probation back in September, and that did not happen. Like, I am getting the runaround with you guys, and I do not feel like this has been fair. I am not disrespectful, so I'm not gonna question your authority during court. If you tell me something that you're gonna do, that's what I expect. That was supposed to be done before this event even occurred. The reckless driving was through now, so I don't even know why you guys would be coming at me for a DUI.
Okay, yeah, well, the indicator I have here is that it's a reckless and an OWI in the 61st District Court. Is that what or did you just get bound over on the reckless?
I didn't get bonded. The reckless was dismissed
I
with
see. Oh, but I still
prejudice.
have the OWI coming in front.
Right.
Yeah, no, and that's the more serious thing, and that's what's going to require, to be addressed by your lawyer.
Your Honor, I wasn't driving, so this is just hindering my life.
No, I get it. And I understand that pending charges and the absconding charge and all of those things have a serious impact on your life. And my flip side of it is, I do apologize. I know it can feel like the system kind of pushes and moves you around without much regard to what's really happening out there. However, I can tell you, from my perspective, particularly with OWI cases, I am in favor of resolving them. However, I've got to look at the unique situation of the concern about public safety when I've got someone with OWI charges, because, as if you got behind the wheel drinking or having used something, as I describe it, it's like shooting a gun into a crowd. You might not hurt anyone, but then again, you might kill someone. And it's just too much of a chance for me as a judge to take. So I've got to be extra cautious with OWI charges, and I always am. Just for the public safety aspect. So that's the best explanation I can give you at the moment. However, once we get an attorney and we get that status conference, we can address those things in front of me. I can advise you, if you plead guilty on another OWI charge, the likelihood is that you'll remain on probation for an additional 3 years. That's my policy, at least on every OWI third charge that comes in front of me. So just so you're, got some parameters to think about going forward. And like I say, if you're successful hiring a new attorney, have that attorney file an appearance. If I don't see an appearance by a week before that status conference, I'll send it over to the county and have an attorney appointed.
She accuses her attorney of manipulation, claims she was forced into signing a waiver, and insists she doesn't owe the court anything, financially, legally, or otherwise. But here's the disconnect: probation isn't optional. It's a negotiated alternative to jail, and it comes with conditions whether you like them or not. Notice how the judge doesn't argue emotionally. Instead, they reframe probation as exactly what it is: a lesser punishment. And that's a reality many defendants struggle to accept. Freedom with rules still feels like punishment, but it's a privilege compared to incarceration. This is also where victim language ramps up. IV never ran,